We are now in lecture 3, part 6 on Ingram's law. Here we're going to discuss two philosophers whom we have already encountered, Habermas and Ackermann, but we're also going to introduce a new philosopher, Derrida. Derrida introduces the notion of forward-looking as opposed to backward-looking legitimation. Habermas has revised his position in light of Derrida, and Ackerman, as before, discusses the Carolyn products case to make his case for the moral essence of constitutional and other types of law. A philosopher of law, Derrida, proposes that the backward-looking approach of the empirical variety by Hart of basing legitimacy of democracy and constitution on empirical choice, or the transcendental variety by Arendt or Habermas by basing that legitimacy on transcendental conditions of possibility of being human, is misplaced. The approach, according to Derrida, should be forward-looking. What is this forward-looking legitimation approach proposed by Derrida? The justification of present constitutional and other laws, according to Derrida, is that they are renewed and reinterpreted by future generations. It proves the usefulness and the validity of those laws, so to speak. We can recall Dworkin's discussion of reinterpretation of the 14th Amendment and also Ackerman's discussion of the reinterpretation of the 5th and 14th Amendments. Those reinterpretations give legitimacy to the amendments, according to Derrida. Habermas later revised his position in light of Derrida. He incorporated the forward-looking justification into his own account of legitimacy of the Constitution, kind of just edited. Habermas wants to peg interpretations to come to the historical tradition from which they are emerging. However, he takes constitutional interpretation to be not simply possible in any which way, but that it must be grounded in the past. So there's a forward-looking, self-renewing historical tradition of interpretation of the Constitution that justified it. Emphasis on tradition. This is Habermas's critique of Derrida. The Derrida's notion of interpretation that justifies laws is too open-ended. Habermas wants to peg it to a tradition of interpretation of rights, how rights have been interpreted in the past, and what the basic essence of those rights is. So, a kind of a Dworkian position on the part of Derrida, on the part of Habermas in his criticism of Derrida. Habermas is like Dworkin and Hegel in this regard. All of them see interpretation as grounded in the moral core of the Constitution. The moral core is freedom, and it constrains interpretation. Interpretation expands freedom by continually creating, deepening, and expanding democratic and civil freedoms. By such means as greater inclusion of marginalized groups and even provision of resources to the vulnerable marginalized groups and perhaps even vulnerable majorities. The latest example that comes to mind is the provision of public and free childcare in New York State. Younger and younger kids are included in that provision by new laws that pass their review by the courts. Whether that review is actually done in a challenge in court or whether that review is done, so to speak, in principle. The courts find or would find that these laws do not violate, but legitimately expand and develop, these interpretations rather, do not violate, but legitimately expand and develop the laws and the moral core of the Constitution that is encapsulated in the basic rights guaranteed by the Constitution. In other words, here we have an expansion of the moral core of freedom to expand into particular laws specifying specific freedoms, such as that of free childcare for the citizens of the state, and those children becoming younger and younger as those who are protected by this by the laws that guarantee childcare to them, right? So here we have the expansion of the moral core of freedom. That wasn't there in the beginning when the Constitution was first laid down. We end with a philosopher of law, Ackerman. He gives us food for thought in light of the latest Hegel, Dworkin, Arendt, Derrida line of thinking about the moral core of law that is continually developed by the court's interpretation of the Constitution. Ackerman reminds us that the meaning of freedom and equality, encapsulated in the Fourth and 14th Amendments, or rather, Fifth and the 14th Amendments, was redefined in the US versus Carolyn Products case in 1938. Judicial interpretation in that case changed the law with regard to procedure as well as with regard to substance. It changed the law with regard to procedure that the courts could now intervene in the economic regulation. It also changed the law in substance. The law became less centered on protection of private property rights and more centered on protection of the vulnerable in economic life, even when this protection came in conflict with the private property, with protection of private property. Examples of the further laws that expand our freedoms, our equal protection under the Constitution laid out in Fifth and 14th Amendments, specific laws would be something like establishing and raising minimum wage, establishing the length of the workday, establishing protection from pollution in the water, in the air, and so on. All of these were made possible by this judicial reinterpretation of the Fifth and 14th Amendment. And all of this we can see as an expansion of the moral core of freedom of the law. Ackerman would like us to dwell on that in our considering whether law is related to morality or whether law runs on its own track.